What happens when a racist senior partner meets a young black public defender he assumes is incompetent? It started on a Tuesday morning in downtown Atlanta, when legendary corporate lawyer Richard Whitman walked into Fulton County Superior Court expecting an easy victory. He'd been practicing law for 23 years, built his reputation on crushing inexperienced public defenders, and he'd never lost a case to what he called bleeding heart do-gooders. But when he saw his opponent, a 28-year-old black woman named Keisha Williams, sitting calmly at the defense table, he actually laughed out loud. "This should be over before lunch," he whispered to his paralegal. What Whitman didn't know was that he was about to face a Harvard Law graduate who had clerked for Supreme Court Justice Ruth Bader Ginsburg, turned down offers from 3 top firms to serve the public, and was about to demolish his case with a legal argument so brilliant it would make national headlines and end his career forever. Richard Whitman adjusted his Italian silk tie as he surveyed Fulton County Superior Court with the confidence of a man who had never lost a case. At 55, he was the senior partner at Atlanta's most prestigious law firm, specializing in crushing public defenders in civil rights cases. His strategy was simple: overwhelm them with paperwork, intimidate them with his reputation, and watch them crumble. Today's case should have been routine. His client, Meridian Financial Group, was being sued for discrimination by Tanya Morrison, who claimed she'd been passed over for promotion because of her race. The plaintiff was represented by the public defender's office, overworked, underpaid lawyers who were easily outmaneuvered. When Whitman saw his opponent, a young black woman in her late 20s wearing a simple gray suit, reviewing notes in a worn leather portfolio, he chuckled to his paralegal. This should be over before lunch. He had no idea that the woman he was dismissing so casually was Keisha Williams, and that she was about to give him the education of his lifetime. Keisha Williams had been preparing for this moment her entire life. At 28, she possessed quiet confidence, earned from years of overcoming obstacles that would have crushed most people. She had grown up in East Atlanta, the daughter of a single mother who worked 2 jobs, and had vowed to become the kind of person who could change systems from within. Her academic record was extraordinary. She had graduated summa cum laude from Spelman College, then attended Harvard Law School on a full scholarship. At Harvard, she had been president of the Law Review, clerked for Supreme Court Justice Ruth Bader Ginsburg, and received offers from prestigious firms. But instead of taking the lucrative corporate job, Keisha had chosen to return to Atlanta and work as a public defender. The decision had baffled her law school professors. "You're throwing away $1 million career," her constitutional law professor had warned. "Corporate law is where you make real change." But Keisha understood something her professors didn't. Real change happened in places like Fulton County Superior Court, where people like Tanya Morrison fought for justice against opponents who had every advantage except the truth. Her Harvard classmates had gone on to prestigious firms, earning starting salaries of $215,000 plus bonuses. Keisha's starting salary as a public defender was $52,000 a year, but she had something her classmates didn't: a purpose that went beyond profit margins and billable hours. The Morrison case had become personal for Keisha in ways she couldn't fully explain to others. She saw her own mother in Tanya Morrison, a hard-working woman who had been told she wasn't good enough, smart enough, or the right fit for opportunities she had earned through merit alone. She saw herself in the assumptions people made about what a young black woman could accomplish in a system designed to favor others. Keisha had been working on the Morrison case for 6 months, and she knew every detail by heart. She had interviewed 12 former Meridian employees, analyzed 5 years of promotion data, and built a case that would expose not just individual discrimination, but systematic bias that had been operating for years. Judge Patricia Anderson was a 60-year-old African-American woman with a reputation for fairness and little patience for lawyers who wasted her time. When court began, Whitman delivered his opening statement with practiced confidence, painting Morrison as a disgruntled employee passed over for legitimate business reasons, not race. "Your Honor," Whitman concluded, "the evidence will show that Meridian Financial Group made a sound business decision based on merit, not race. We respectfully request that this court dismiss these claims entirely." When Keisha approached the podium, she spoke with calm authority. "Your Honor, This case is about more than one woman's career. It's about a pattern of discrimination that has been hiding in plain sight at Meridian Financial Group for years. She presented devastating statistics. In the past 5 years, Meridian promoted 47 employees to management. 42 went to white employees. The remaining 5 went to employees of color, and in each case, those employees had performance metrics significantly higher than their white counterpart. Whitman felt his first flutter of unease as Keisha continued. When employees of color complained about being passed over, they were subjected to retaliation, including negative performance reviews, increased scrutiny, and in some cases termination. But this was just the beginning. "Mr. Whitman," Judge Anderson said, "call your first witness." Whitman's first witness was David Bradley, Meridian's HR vice president. Bradley was carefully coached, presenting the company line that Morrison lacked leadership skills necessary for management. His testimony was smooth and rehearsed, citing specific examples of Morrison's alleged failures. Whitman felt confident until Keisha Williams stood up for cross-examination. "Mr. Bradley," Keisha began calmly, "you testified that Ms. Morrison lacked leadership skills. Is that correct?" "Yes, that's correct." Keisha picked up a thick folder. "I'm showing you Plaintiff's Exhibit 1. Do you recognize this document?" Bradley examined the email, his expression growing puzzled. "This appears to be an email from my office to the promotion committee, sent 3 days before Ms. Morrison's promotion interview. Would you please read the highlighted portion to the court?" Bradley's face went pale. The email, which he had forgotten about, directly contradicted his testimony. He had written that Morrison was obviously the most qualified candidate, but that the company was concerned about promoting another black employee to management so soon after the Jenkins situation. "Mr. Bradley, you just testified that Ms. Morrison lacked leadership skill, but in this email you describe her as obviously the most qualified candidate. Can you explain that contradiction?" Bradley stammered. "That email was taken out of context. I was referring to her sales numbers, not her overall qualification." "And what was the Jenkins situation you referred to?" Bradley looked panicked. The Jenkins situation was a discrimination lawsuit filed by another black employee, settled out of court with a confidentiality clause. "I don't recall the specific details," Bradley said weakly. Keisha smiled for the first time. "Mr. Bradley, I'm showing you Plaintiff's Exhibit 2. This is the settlement agreement between Meridian Financial Group and former employee Marcus Jenkins. Mr. Jenkins waived the confidentiality clause to testify in this case." Whitman's objection was overruled. For the next hour, Keisha systematically dismantled Bradley's testimony with email after email showing executives were aware of discrimination complaints but chose to ignore them. The most devastating moment came when she presented a recorded phone conversation between Bradley and another executive discussing the need to find a way to get rid of some of these diversity hires before they become a problem. By the end of Bradley's testimony, Whitman knew he was in trouble, but he wasn't ready to give up. His next witness was Jennifer Walsh, the employee promoted instead of Morrison. But Keisha was ready for her too. "Ms. Walsh, you testified that you were promoted because of your superior qualifications. You've been with the company for 2.5 years, while Ms. Morrison had been there for 5 years. Looking at this sales comparison chart, whose numbers are higher?" Walsh studied the document uncomfortably. "Ms. Morrison's numbers are higher, significantly higher, wouldn't you say? In fact, 40% higher in the year preceding the promotion decision. That appears to be correct. And Ms. Morrison brought in the Henderson account, worth over $2 million, while your biggest client acquisition was worth how much?" Walsh's voice was barely audible. "About $300,000. Given that Morrison had been with the company longer, had higher sales numbers, and brought in significantly more revenue, can you explain why you believe you were more qualified for the promotion?" It was devastating. Walsh had no good answer, stammering about intangible qualities that sounded hollow. As Keisha destroyed each witness with surgical precision, whispers began to spread through the courtroom. Law students who had come to watch what they thought would be a routine case started taking notes furiously. Legal reporters realized they were witnessing something extraordinary. This wasn't just another discrimination case. This was a masterclass in litigation strategy. "Who is this woman?" whispered a reporter from the Atlanta Journal-Constitution to her colleague. "I don't know," came the reply. "But she's destroying a legend." A crowd of observers grew as word spread throughout the courthouse. Veteran attorneys began slipping into the gallery to watch Keisha work. They had heard about the young public defender who was single-handedly dismantling one of Atlanta's most powerful law firms, and they wanted to see it for themselves. Judge Anderson, despite her reputation for maintaining strict courtroom decorum, found herself genuinely impressed by the quality of legal work she was witnessing. In 15 years on the bench, she had rarely seen such thorough preparation and strategic thinking from any attorney, let alone a public defender with limited resources. During a brief recess, Whitman's paralegal approached him with panic in her eyes. "Mr. Whitman, the partners are calling. They're getting calls from clients who are watching this on the legal news feeds. They want to know what's happening." Whitman loosened his tie, feeling the weight of 23 years of success crumbling around him. "Tell them we're exploring settlement options," he said quietly. But the damage was already done. By the time the recess ended, videos of Keisha's cross-examination had been posted on legal blogs and social media. The hashtag Courtroom Masterclass was trending on Twitter. Law professors were already assigning the case transcripts as required reading. When court resumed, Keisha's demolition continued. She called witness after witness, each one adding another piece to the puzzle of systematic discrimination at Meridian Financial Group. Former employees testified about being passed over for promotions, subjected to different standards, and retaliated against for complaining about unfair treatment. The smoking gun came when Keisha called Marcus Jenkins, the former employee whose confidential settlement had been exposed during Bradley's cross-examination. Jenkins, a soft-spoken man in his 40s, described how he had been denied 3 different promotions despite having the highest performance ratings in his department. "Mr. Jenkins," Keisha asked, "what reason were you given for being passed over for the regional manager position?" "They said I wasn't leadership material," Jenkins replied. "They said I was too aggressive in my sales approach and that clients might not respond well to my style." "And what did you understand that to mean?" Jenkins paused, his voice growing steady with resolve. "I understood it to mean that I was too black for their white clients." As the day progressed, the courtroom became a theater of legal education that would be studied for years to come. Keisha's systematic destruction of Whitman's case was methodical, precise, and utterly devastating. She had anticipated every defense strategy, prepared for every possible objection, and built a case so airtight that even Whitman's legendary reputation couldn't save him. The moment that would be replayed in law schools came during her cross-examination of Meridian's CEO, Robert Thornton. He was used to deference from attorneys intimidated by his wealth and status. He was not prepared for Keisha Williams. "Mr. Thornton, you testified that Meridian has a strong commitment to diversity. Is that correct?" "Yes. Absolutely. We've won awards for our diversity initiatives." Keisha approached with a thick folder. "I'm showing you Plaintiff's Exhibit 47. This is an email from your account discussing Ms. Morrison's promotion. Do you recognize this?" Thornton's confidence wavered. "I'm not sure I recall this specific email. Would you please read the highlighted portion to the court?" Thornton went pale as he read the email he'd forgotten. In it he had written, "We need to be careful about the Morrison promotion. The board is already asking questions about why we have so many diversity hires in customer-facing roles. Let's find a way to pass on this one without creating legal exposure." The courtroom fell silent. Even Whitman stopped writing and stared at his client in horror. "When you wrote diversity hires, what did you mean?" "That was taken out of context. I was referring to our overall hiring strategy. At the time you wrote this email, how many black employees held management positions at Meridian?" "I would have to check the records. The answer is 2 out of 47 management positions. That's 4.2%. Black residents make up 32% of Atlanta's population. Can you explain why the board would be concerned about having so many diversity hires when black employees represented less than 5% of your management team?" Thornton had no answer. He stammered about qualified candidates and business needs, but his explanations rang hollow. The cross-examination continued for 2 hours, with Keisha systematically exposing every aspect of Meridian's discriminatory practices. That evening, Keisha received a phone call from Justice Ruth Bader Ginsburg's chambers. "Keisha, I've been following the Morrison case. What you're doing is exactly why I encouraged you to pursue public interest law. You're not just winning a case, you're changing my—" "Thank you, Justice Ginsburg. I keep thinking about what you told me, that the law is only as good as the people who practice it, and you are proving that principle every day. The legal profession needs more lawyers like you." The call reinforced what Keisha had known since Harvard. Success was measured by impact on others' lives, not paycheck size. The next morning brought news that would send shockwaves through the corporate world. Meridian Financial Group's board had called an emergency meeting, and by noon 3 senior executives had been terminated. The company's stock price had dropped 12% in overnight trading. But for Keisha, the most important news came in a text message from Tanya Morrison. "Thank you for believing in me when no one else would. You didn't just win my case, you gave me back my dignity." That text message reminded Keisha why she had chosen this path. She hadn't become a lawyer to make money or gain fame. She had become a lawyer to fight for people like Tanya Morrison, people who deserved justice but couldn't afford expensive representation. The settlement negotiations that followed were swift and decisive. Meridian's attorneys, recognizing the hopelessness of their position, quickly agreed to Keisha's terms. $3 million in damages, a promotion to regional manager for Tanya Morrison, and a comprehensive diversity program monitored by an independent third party. The next morning, Keisha found a settlement offer waiting. Meridian Financial Group was offering Tanya Morrison $3 million, a promotion to regional manager, and implementation of a comprehensive diversity program overseen by an independent monitor. It was a complete victory. The settlement made national headlines, and Keisha was inundated with job offers from prestigious law firms offering partnership tracks and 7-figure salaries. She turned them all down. 6 months later, Keisha Williams was named director of the Fulton County Public Defender's Office. In her acceptance speech, she talked about the importance of ensuring everyone had access to quality legal representation, regardless of their ability to pay. "There are brilliant lawyers working in public defender offices all across this country," she said. "Excellence doesn't require a corner office or a 6-figure salary. It requires preparation, dedication, and a commitment to justice." Richard Whitman wasn't there to hear that speech. The Morrison case had ended his career as a high-profile corporate lawyer, and he was now working as a staff attorney at a small insurance defense firm. But the case had taught him that assumptions were dangerous things, and that the young public defender he had dismissed so casually had been everything he had claimed to be, and more. The aftermath of the Morrison case sent shockwaves through Atlanta's legal community that would be felt for years to come. Within hours of the settlement announcement, Keisha's phone began ringing with calls from major law firms, corporate clients, and civil rights organizations. Everyone wanted to know the same thing: where had this legal prodigy come from, and why hadn't they heard of her before? The answer was simple and damning. They hadn't been looking in the right place. While they had been focused on recruiting from their own networks, the children of wealthy families, the graduates of elite undergraduate schools, the associates who looked and sounded like them, they had missed the brilliant minds working in public defender offices, legal aid clinics, and small practices across the country. Keisha's success story became a wake-up call for an industry that had long prided itself on meritocracy, while systematically excluding talented lawyers who didn't fit the traditional mold. Law schools began studying the Morrison case not just for its legal strategy, but for what it revealed about bias and assumptions in the legal profession. The case also had immediate practical consequences. Meridian Financial Group's stock price plummeted as investors worried about potential liability from other discrimination lawsuits. The company's board of directors launched an investigation into their human resources practices, and 3 senior executives were terminated. The comprehensive diversity program that was part of the settlement became a model for other corporations facing similar scrutiny. But perhaps the most significant impact was on the career trajectories of young lawyers who had been watching from the sideline. Applications to public defender offices increased by 40% in the year following the Morrison case. Law students began seeking out clinical programs and pro bono opportunities that would give them real courtroom experience rather than just prestigious internship. Keisha herself became a reluctant celebrity in the legal world. She was invited to speak at law schools, bar associations, and civil rights conferences. Magazine profiles described her as the public defender who changed everything and the lawyer who proved that excellence knows no boundaries. Despite the attention, Keisha remained focused on her work. She knew that the Morrison case was just one victory in a much larger fight for justice and equality. There were hundreds of other cases waiting on her desk, hundreds of other clients who needed someone to fight for them with the same intensity and preparation she had brought to Tanya Morrison's case. The young woman who had once been dismissed as just another public defender had proven that sometimes the most powerful force for change comes from the most unexpected places. And in doing so, she had reminded everyone that in the pursuit of justice, assumptions are the enemy, and the only thing that really matters is the truth. In the end, the most important lesson was that talent, intelligence, and dedication can't be measured by the color of someone's skin, the size of their paycheck, or the prestige of their office. They can only be measured by results and by the courage to stand up for what's right, even when the odds seem stacked against you. Keisha Williams had demonstrated both, and in doing so, she had changed not just one case, but the entire conversation about what it meant to be a lawyer and what it meant to fight for justice in a world that too often confused privilege with merit. The story of Morrison Meridian Financial Group would be told in law schools for years to come, not just as an example of brilliant legal strategy, but as a reminder that the best lawyers aren't always the ones with the most advantages. Sometimes, they're the ones who have had to work twice as hard to get half as far, and who have learned that preparation, dedication, and an unwavering commitment to justice are the only things that really matter in the end.